Okay, welcome, ladies and gentlemen. I'm going to go ahead and ask people to go ahead and settle down into the non-blue marked seats. And as we begin to get ready for this meeting, I won't call us into order exactly yet. While we're dialing up the Zoom meeting, we are going to take roll because we may have some people in electronically that aren't in the meeting. And as I said, I've communicated with several members and communicated from the House floor today. If you are attending electronically, we will allow folks to vote that way. Given the size of the room, we were scared of everybody being able to fit in, and I know some people specifically said they were going to be in their office and give other members opportunity to be here. So we are going to proceed with that. We have before us today, we'll be taking up Senate Bill 318 by substitute. You should have that in your packet, LC 490235. There's a sign-up sheet down there someplace, and if there's not objection, again, we have people that have made aware, specifically folks in the university system that may be available to answer our questions and or speak to the bill. They are going to do that remotely, just in the interest of having less individuals in a room to help us with our strategic positioning. I'm going with strategic positioning because I've heard social distancing one time too many. So we're going with the military version of it and call it, we're strategically positioned today, 6 feet apart. So thank everybody for being here. Oh, and that's the greatest thing. You now get to see yourself over there on that monitor with a mask hanging off of your ear. So if we're ready here, everybody that wishes to speak is signed up. The senators here. I'm going to turn it over to Patrick Lovett and let you call our roll. Or, well, then hand me your, if we would follow the same protocol that we're doing in the House chamber, if you would just sing out with a here, or if I see you in the room, I'll mark you present. And
at the end, we can acknowledge those who are on.
Right. Representative Reeves.
Here.
Kelly. Bentley. Representative Bentley was here. She will be back. Just put a star by that. Bernal.
Here.
There you are. Dempsey.
Here.
Dickey.
Here.
Dreyer. Dubnik.
Here.
Earhart.
She is on Zoom.
She's going to be on Zoom. Okay. Gardner.
Here.
Holcomb. Holland.
Here.
Jaspers. Kausha.
Here.
Knight. Mafiak.
Here.
Metz.
Here.
Park.
Here.
Perkle.
Here.
Representative Park, you're always making a good interest there.
He was just showing up.
Yeah, there you go. Just not on the blue X. Perkle.
Here.
Smyrie. Washburn. Williams, Rick. And the chair is here. Okay. Now I'm going to read. I don't know how we're going to do this, but I'm going to be very, very careful. You know what? I may have just jumped past you. Dr. Clark. I think he had you in here. I've just skipped over your name. I'm sorry. This is new. Y'all have to really bear with me. I feel like I've been doing this for a number of years, and yet we have something completely new here. So I have Reeves, Bentley, Bernal, Clark, Dempsey, Dickey, Dubnik, Earhart, Gardner, Holland, Kausch, Mafiak, Metz, Park, Perkle. Anyone that we've missed? To the folks that are looking at the Zoom meeting, do we have any additional folks on Zoom?
Showing Earhart, Perkle is there, and that is it. The rest is our invited testimony.
Okay. Very good. Well, then we will move forward then in the presentation. Everyone has, I don't think we passed out packets today. We let you pick up your bill again to keep with the minimal touching and getting you the information you need with as little impact as we could. So without further ado, Senator, I don't know where they have you presenting from today. Perhaps the the podium, if you would do that, Senator Ligon. We have LC 490235S.
I've gotten a version earlier, but I don't have it with me. But I know that this committee has previously heard a very similar bill that it passed out, and while I'm not familiar with that bill, I believe that the intent is certainly to accomplish the same thing. And what we've seen, unfortunately, even in Georgia, across our college campuses, is that the rights of students to exercise their the freedom of speech, rights granted to them under the Constitution, has run into some difficulty, and we've seen litigation arising out of these claims. In fact, I believe there is currently a suit pending against Georgia Tech out of an issue like that, and someone coming after me perhaps can speak a little more to that and to some of those claims. But basically what we want to do is eliminate these so-called free speech zones. And these are zones on our college campuses where students are told this is the only area where you are to exercise your free speech rights. And that's not what the First Amendment is about. The bill also recognizes that there need to be reasonable time, place, and manner restrictions. I mean, you can't exercise that right in the middle of a lecture in a classroom, and certainly not outside of a dormitory at 3 a.m. in the morning. You shouldn't be screaming and shouting and disturbing the students that are trying to get rest in order to go to class and to study. So all of that is contained in the bill. I mean, I could walk you through it, but I think you've already basically been through the same bill earlier when you passed it out. Now, Mr. Chairman, I don't know, as far as, I know you've made some changes to the bill, and I don't necessarily feel that I'm qualified or really prepared to address the changes in the committee substitute, and would be glad to defer to you or to whoever you feel should address those points.
Senator, I had to juggle both these. I'd leave us on both in at the same time, but I think we're gonna have feedback. I'll be glad to do that. I'll explain. In fact, if you would stand there for a moment, I probably should have introduced the concept that we were going with. If I can, to the members, the Senate substitute, or the substitute to Senate Bill 318 that you have before you, started with the basis of House Bill 995 that we passed out of this on one of our meetings before we went on recess. It does have slight changes to that language. Those changes are the definition in the previous bill, and I call your attention to line 40 of the current substitute. Previously in the House bill, there was a definition for materially and substantially disrupts. The Attorney Walker has changed that so that we are defining what a material and substantial disruption is. And then if one does that activity, that means one is disrupting. Because we had a bit of a circular definition in the materially and substantially disruption. But we tried to capture what we had done before. We did merge a bit of what was in the Senate bill that wanted some specific instances highlighted. The House bill was gave a little more latitude on campus, so that there you find a bit of a merger in that definition. That is on line 40. It also appears, if the committee will recall, there's two sets of language here. One that applies to the University System of Georgia. Another one applies to the Technical College System. So that mirrored language, and we can get the attorney to speak to exactly what went on there. Also would call the attention over to page 4, line 107. If the committee will recall, in the previous version, when this is the association portion of the bill, And in the previous version, there was a bit of a double negative. It started out, it had been edited over time, and so that it got into no institution shall not. It was a bit confusing to read. So what the learned attorney has done here is to try to correct that by simply stating a public institution of higher learning shall not deny. And the crux that we're trying to come up with here is every group, regardless of their actual or anticipated expressed activities, will be treated the same, and they can be discerning for their leaders and members, but they have to do that within the rules of the institution. Provided, however, this on line 112, provided, however, that nothing on this part shall be interpreted as preventing the public institutions of higher education from requiring organizations to comply with the rules. And then belt and suspenders, provided further that these rules do not violate. If you recall previously, we said do not violate the First Amendment, the speech amendment. We've went even further there, and we say do not violate anything in the constitutions of the state of Georgia or the United States. That should go without saying, but we have it right there in black letter law. So those are the two changes in language that we have from the House version. And if committee members have any questions, and we're trying to monitor Zoom, Mr. Attorney, Michael Walker, have I explained that correctly? Would you like to opine on that? Are there committee questions? If I can, and then we'll go to Representative Park. I know the senator, I know you had some additional language about cause of action. That was not in the previous House bill. We have also kept that out of this, just to let the members know you get an opportunity. If you get favorable consideration today, you may choose to wrestle with the House over that in the future, but today we're back to that version. Representative Park, you are number 3. Yes, sir.
Thank you, Mr. Chairman. Thank you, Senator, for the bill. I think all of us can agree the importance of protecting First Amendment free speech rights for our students. If I may, I did have 2 questions. First, could you discuss and give us a few more examples about the severity of the problem in which college campuses may be infringing upon students' free speech rights?
Sure. For example, we could go to the Georgia Tech case that's pending right now. A student group had asked Coretta Scott King, Ms. King, to come in and speak, Dr. King's niece, but the student organization said, no, she can't come because she's too religious. And, why should they get to decide that? Our institutions are to be a place where ideas are exchanged and challenged, and certainly there's students that wanted to hear from her, and she should have been allowed to come. And that organization should not have had to file suit to assert their rights. And we think that this bill would make it clear that free speech is to be honored in activities such as that, or actions on the part of the university or university organizations is not proper and does not certainly comply with the First Amendment.
Mm-hmm.
So.
Thank you for that answer. So I wanted to focus in on 2 specific components of the bill, if I may. First, on lines 51 to 53, when we're talking about material and substantial disruption, part of the definition is that the mere undifferentiated fear or apprehension will not be sufficient to deem conduct as being material or disruptive. Who determines that piece? Is that discretion, does that remain with the Institution of Higher Learning or USG?
If I may, in deference to the senator, I'll give deference to you if you wish to answer that. That was an extension of the definition that Mr. Walker came up to cover the items better. We had a circular definition in the House's version previously. So, Senator, I'll allow you to answer that question if you want. If you want to hand that off to Mr. Walker, I will put him in the box, put him on the clock, if you will.
That is correct. This definition was revised to try and attempt to harmonize the definitions that were originally in the House Bill 995 that this committee approved prior to the suspension, and the definition that was in Senate Bill 318. So this language is substantially similar to what was in Senate Bill 318, but to specifically answer your question, ultimately the analysis there would be, did the public institution of higher education properly determine that this was something, either a mere undifferentiated fear or was something greater than that? If the decision to take some official action was based on something that ultimately boiled down to nothing greater than a mere undifferentiated fear, then that would be more likely to create some constitutional difficulties for the public institution of higher education.
Okay.
If they had tried to step in and prevent a speaker or prevent recognition, deny recognition, or take some official action based on that kind of thing, then that would create perhaps a greater likelihood of some constitutional challenges and problems.
I asked that question just because I think, given the hyper-partisan era in which we live in, there are certain organizations in which folks may be fearful of that others are not. And so given the subjective nature of whether or not a material or substantial disruption occurs, that's kind of the gist of the question in and of itself.
I would suggest perhaps the critical term there might be undifferentiated.
Okay.
And so if you could ascribe some reason for the fear, then that might be something that would differentiate it, to say, I am fearful because of either this activity, this anticipated speech, something that gives you a basis for your fear, as opposed to just, I am generally afraid of a group that represents something. That would, under this definition, not be enough to rise to a material or substantial disruption.
So Chairman, if I may, one more follow-up question. Thank you. So that question kind of dovetails into some of my concerns raised, some concerns that come to mind from lines 107 to 116. I think I had problem with language in this, in a former bill that passed this committee, or that may have been taken out, where it essentially denies an institution of higher education the ability to deny a prospective student organization from official recognition, any benefit or privilege, assuming that benefit or privilege includes taxpayer dollars. Does that, again, I think I asked this question last time, would this prohibit a college in Georgia from denying a benefit or privilege to a, let's use a hypothetical, a neo-Nazi group, or an Antifa group from forming on a college campus here in Georgia?
Or a religious group like happened at North Georgia College would be a real life example of that, where you had a group of a Christian sorority, and they wanted to renew their charter and or their status to have activities on campus. And they were told, well, no, you cannot do that unless you, because you're requiring your members to adhere to the Christian faith. And so, you have to, if you're going to protect groups like that, then you may have to protect some others as groups as well. So,
Senator, yes, if I may ask, in regards to the real life example, if that Christian organization wanted to discriminate against the LGBTQ community that violated the institution's policies, would this provision allow the institution to continue to prohibit that organization from discriminating against LGBTQ
yes, the
students?
institution would need to say, listen, would have to recognize that, a group, they have certain beliefs that they should be free to follow and adhere to, just like we do here. I mean, in our real, in this building, in our legislature, we have two parties. We have the Democratic and the Republican Party, and we have our own caucuses. And I cannot go to one of your caucus meetings or to a Democrat caucus meeting because I have not adhered to those principles. And our Constitution guarantees the freedom of association, and this bill is just reflecting the principles that are enunciated in our United States Constitution and in our Georgia Constitution. And we're just bringing this in line with when the Constitution, and two, the real practice that we actually live under here in this body here and in our state and in our nation. So.
Yes, thank you.
Uh, What is your number?
Which
on
one? Okay, then I had number 1 here somewhere. Oh, I'm sorry, Pat. I thought that, can I go to Roseanne Gardner? She had number 1 pressed, and I thought number 1 was down there. So they've renumbered. Roseanne Gardner, you're right.
Thank you very much, Mr. Chairman, and thank you to the senator for trying to make sure that we have free speech on our campuses. I agree with you that it is extremely important. At our last meeting a long time ago, I remember there were some testimony that the cases that you described had been resolved one way or another by the university system. Is that still
Well,
true?
Actually, one of them I believe is still pending, but the one with North Georgia was resolved. But the point is, why are we requiring our students to have to go through that process for something that should be guaranteed to them under our Constitution? I mean, so there's still ongoing litigation, as far as I know, from the case that was filed back in January or February or maybe March of this year.
I am concerned, and this is more a statement than a question, but as we seek to redefine what disruption is, and the language ultimately requires some interpretation by the institution of higher learning. And however that institution interprets or decides what is really disruptive or what is undifferentiated fear, I think that opens the university up to even more litigation. So I am concerned that this, we all believe in the First Amendment rights, and it seems to me that that is the law of the land at this time. So I struggle with why we need this legislation, and I fear it will actually lead to more lawsuits.
Actually, I believe that a lot of the language has been drawn from existing case laws, but actually bringing it into a statutory form so that it's clear, it's easily accessible, and there's no ambiguity or doubt about this for our university officials. And with regard to that language, I believe one of our other witnesses would be able to maybe direct you to case law that would address the section that you're concerned about.
Well, with all due respect, lawyers can always find an excuse to bring a case. So I really believe this language will add to the possibility for litigation. So, but thank you for your efforts.
Dr. Clark, I'm going to go to you next. Let me just mention, again, as just noticed by my board, number 1 is usually down there where Dr. Clark is. Now it's not when you press the button. If you're not at one of these tables and you wish to speak, you're going to have to do it the old-fashioned way and throw your hand up because you don't have a button to press. So I don't want to, if folks on Zoom have a question, you have a method electronically to raise your virtual hand, and we'll bring you into the conversation as well. Dr. Clark, and you're at microphone number 7, you think?
Yes.
There you go. Okay.
Thank you, Mr. Chair. Thank you for coming here today. And again, thank you, as my colleagues have stated, for protecting free speech and just our First Amendment rights. My question actually is specific to the Georgia Tech case that we keep referencing. I looked up the case, and that case is specifically about funding for student organizations.
Right.
And I am curious if in this bill, as you understand it, does it address funding for student organizations? Because the way I just, if you bear with me, the way I understand what this bill is seeking to do, the students were still able to have their speaker come on campus. The issue at hand was that they want to be reimbursed for the speaking fees, and it was the fees that were denied. And so I'm wondering how this particular legislation fixes that.
Well, the funds for those fees were available to other organizations as well. And that funding enabled the speakers to be brought in and free speech to occur. And so the thought is that, well, when the funding is denied, then the speech is also denied too. And why did that denial occur? It occurred because of the content of that particular speech, and or the perceived the perception that in someone else's judgment that the speech was not appropriate. And so that's how I think that the connection is here. But one of the attorneys that's actually, I think, more familiar with the case could address that clearly. But that's how I believe that the connection would be made and how this bill would help avoid that in the future.
So can I ask a follow-up to that?
Yes.
So is it my understanding that in this bill, we seek to take away an institution's discretion on how to distribute funds across different student groups?
Again, since we reworked that portion of the association bill, if the senator doesn't mind, let me make a shot at that, and then I'll yield to the senator. What we seek to do on lines 107 and 108 is a public institution of higher learning shall not deny a student organization any benefit or privilege. The fees that are collected with student organizations are divvied out, collected the way they decide they do that. We don't tell them they have to. I personally might take the position that they shouldn't charge fees and give them to any organizations if it were I, but they do that now. And what the bill seeks to do is, if you're a valid organization on a campus and you have access to X, they can't tell you how to spend X as long as you're abiding by the rules and policies. You know, they can't tell you that Miss King can't come and be compensated for coming because they particularly don't like what she may or may not say. They don't have to give you more money. They don't have to pay anybody for it. But if they give you an allotment of money, they can't tell you how to speak. That's what we were trying to do, Senator, when we reworked the association clause. Now, I'll yield to your original intent, but we weren't trying to tell them they had to do something or direct them, just that you had to treat everybody the same.
I mean, you stated what the bill before you does. So.
Yeah, well, this is, I guess, just a follow-up to what you're saying. If there is a policy in place at the institution that says that we will not use fees to pay for religious speakers, does this bill take that policy away? As long as it's across the board, no one can bring in religious speakers. Does this bill now tell an institution you can't do that? I'm just trying to get clarification on what we are now telling universities they can or cannot do.
I don't, if you don't mind, let me weave that into that. I'm trying to give you an answer, not dodging your question.
Okay. Thank you.
So if I may, I'm going to ask Attorney Walker to come up and ask it today following, gosh, too many microphones, so many masks. All right, I'm going to have to ask the question and then turn your microphone on at the same. So I think the question from Dr. Clark is, if today there's a policy that says you can have all these organizations across campus, but we treat religious organizations different from agricultural organizations, is that a policy that would stand constitutional challenge with or without this legislation? Do you care to opine on that?
I will do my best. A general principle is that public organizations need to maintain viewpoint neutrality and content neutrality. So as long as they have a set of rules that are uniformly applied and essentially ignore the viewpoint or the content of the speaker, as long as you're not talking about illegal language, fighting words or something like that that could arguably just be illegal per se, then that could be problematic. I don't know if Senator Ligon has anything But I think that could be problematic if you were to say, no, we're not going to allow religious content that gets into the content or the viewpoint of the speakers. And what the public institution is supposed to do is to be viewpoint neutral and to not stand in and say, you can say things like this, you can't say things like this. If you open up your organization to provide a public or a semi-public forum, then you essentially are opening it up to anyone who wants to use it. You can apply rules, but those rules have to comport with the constitutions of the state of Georgia and the United States.
Board, then it's,
Uniform application is going to
Yes.
be your best friend in that case.
yes,
yes.
thank you. That's it, Mr. Chair.
Number 20. Thank you, Mr. Chairman. Thank you, Senator, for your presentation on this legislation. I'm just curious to know, I was a little late coming in from another meeting, but I just want to know what's the University System of Georgia's take on this particular bill now?
Well, I don't know where they are on this particular version which is the House substitute. I know that on the Senate version, we worked with them on a lot of issues. There was still some disagreement on several points, but the bill obviously moved out of the Senate. So,
Is anyone here from the Board of Regents, Mr. Chairman?
There's a minute, we have them on, I'm sorry, I'm hearing feedback. I don't know if y'all are, so I'm having to juggle we have representatives from the university system that are signed up for Zoom to give us, again, that you weren't here when to give us more space in the room, since they're well set up across the street electronically. They can provide that. I do know that there were some issues in the Senate bill that the university had some concern with about personal cause of action. Those things we had out of the original House bill, they are out of this bill. This bill is the House bill with some language modifications into material and substantially disrupt what a material and substantial disruption is, and removing the double negative language from around lines 107, and it's in the technical section as well, to make that read better. But we'll have the university system on.
We can ask them now.
Yeah, we
Call on Brooke.
okay.
And then switch to.
All right, we're going to try to get somebody on here to speak to us virtually. So hold on, everybody. Okay, I can't have it on at once. So, University of Georgia system,
Brooke Rowan.
Brooke, I'm just going to go with you.
Good afternoon, Chairman Martin, and good afternoon, representatives. Thanks so much for the opportunity to be here. As to the university system's position on this bill, we still take the position respectfully that the legislation is not needed, that there are adequate protections in both the U.S. Constitution and the Georgia Constitution. That being said, the current version of Senate Bill 318 that has been presented as a substitute today, we do believe mirrors federal case law, and so we are okay with this current version of the bill.
Okay, I have to, we may have a question for you, Brooke, if you would hang with us. We can only we have to either talk in here or go there. So I'm fine. You can ask the question. I'm just explaining to Brooke how we turned her off completely while you're getting the question. So that's why she went away on the screen. Yes, Representative, you have a question.
So my apologies for making you disappear. So, so my question is, if you continue, well, we talked about this bill before in the House in this committee, and your position was that you think that the bill is not needed because we already have the protection under the Constitution. Now, if we implement this bill, do you expect any costs affiliated with this bill resulting from the provisions? For example, I see here in line 121 that you're supposed to educate, provide material. Is there any cost affiliated you expect out of this bill?
We're turning this over to Brooke now.
Thank you. Thank you, Representative. There may be some minor cost. Our policies are already up to date with the First Amendment. There may be some minor cost in terms of orientation training, but as we've all noted, the First Amendment is incredibly important. Many of our institutions are already doing this training anyway. We're already doing the training for our faculty and staff, so they are costs that we could handle. So as this current version of the bill, we feel comfortable with.
Thank you. Again, I hate to turn Ms. Bowen off every time I have to turn on the mic. She goes away. Any further questions? We'll call the university back if we need. Committee have further questions? Representative Gardner, your button was pushed, I think, before we went to Ms. Bowen. Do you have a question? Any further questions? Senator, if not, I'll let you reside there for a second, and we'll have the speakers come forward.
Can you acknowledge attendance?
Oh, yes, I would wish to acknowledge additional members that have joined. Representative Wiedauer, Representative Smyrie, Representative Kelly, Representative Dreyer, and Representative Knight. And now we will, I would fail miserably as a movie director. I can tell with all this going around. Chris Bruce from ACLU of Georgia. Mr. Bruce.
Thank you, Mr. Chairman. Members of the committee, thank you for having me here today. We just became aware of the Senate substitute. Let me start back. Hi. Good afternoon. My name is Christopher Bruce. I'm the political director for the ACLU of Georgia, an organization dedicated to protecting your civil rights and civil liberties, especially under the First Amendment. So I have a long testimony right here that I'm not going to share. And the reason why I'm not going to share is because a lot of our biggest concerns were actually addressed in the Senate substitute. However, we still believe that this piece of legislation is not needed, as the University of System of Georgia has already stated. So I'll hold my remarks for you and look and see how it works out with the committee, but I am here as a resource as well on behalf of the ACLU.
Thank you, Mr. Bruce. If I can just to clarify your remarks, you had some issues with the Senate bill as it came out. The House version, the version you have in front of you that we've overlaid the House version with the current changes. I won't put words in your mouth that you're supportive of, but you're more friendly to that. It took care of some of your concerns. Is that fair? Because I just wanted to capture the difference between the Senate substitute. It's the bill we have before us today gives you more peace, if you will, than you previously had this morning.
Dive into the Senate substitute, but it seems like, and one of our biggest concerns was about the university making sure that discrimination and hatred was not promoted. And we believe that the Senate substitute at this time may address that. So we may come back later with something different as far as we go down with legal precedents, bringing up the case that happened in Kennesaw State University with the cheerleaders who were kneeling, and that cost taxpayer dollars a lot of money. So again, still believing that this piece of legislation is not necessary, but going into a deeper dive, we can come back with further comments. Thank you.
Would the gentleman stand for questions if there are any? You're not required to do so.
Yes, Mr. Chairman.
Are there questions? I see none. Thank you very much.
Nobody likes to ask questions, but I'm here.
Nobody, I think maybe people are getting wary of wearing the mask.
I am too.
Getting warm in here. Tony West from AFPA of Georgia.
Thank you, Mr. Chairman. Members of the committee, my name is Tony West. I'm the Deputy State Director for Americans for Prosperity, Georgia. I encourage this committee to support Senate Bill 318 because it will ensure Georgia's public universities no longer have policies that unconstitutionally infringe upon students' lawful speech and expression. This bill will strengthen our universities and protect our taxpayers by ensuring that schools adhere to the First Amendment. You heard my testimony a few months ago, but in light of some recent events, I wanted to contextualize a little bit how I think this bill could positively impact our state and our schools. This forum legislation is going to protect the First Amendment on campus, regardless of how uncomfortable it may be. So in the context of what our country's working through right now, this means daughters of police officers and sons of alleged victims will be in the classroom together, holding uncomfortable conversations that will help us learn, grow, and enact needed reforms. This bill will allow that to happen more successfully. If you look at line 121, campus police officers will be trained to make sure that they know what is expected of them and what protections students have on campus. That's something that's being discussed in our country right now in other manners. We're witnessing right now how important it is for people to speak out on critical issues of the day without fear of retribution or punishment from our government or those who act on behalf of our government. And this bill is critical to ensuring that speech is protected for our college students on our public university campuses. It's not just students on our campuses who are going to benefit from the robust debate that will occur if Senate Bill 318 becomes law. All of us will benefit because today's college students are tomorrow's members of this committee, our judges, our teachers, and our community leaders. And by not just teaching them about our First Amendment freedoms, but providing them an opportunity to exercise those freedoms, our universities will create future leaders of our state who are open to dialogue and open to debate. So for that reason, I encourage you to vote yes today. Thank you so much for your time.
Thank you, Mr. West. You have no questions. Thank you very much. I'm sorry. Yes, sir.
What's your number?
Do you have a number?
There should.
22. Yes, sir.
Thank you, Mr. Chair. No, thank you. You referenced earlier testimony. I just want to ask, I guess, two brief questions. One, have there been any incidences since the testimony on Representative Bonner's bill where First Amendment rights were oppressed in any way on college campuses that you're aware of?
Since that testimony, just the one, to my knowledge, became public, and that was the Georgia Tech incident that Senator Licken just mentioned.
Okay, well, how was that resolved?
My understanding is that litigation's pending, but I believe another person providing testimony can actually give you the full details of that.
Okay, I'll wait for that.
Thank you.
Chairman Dreyer, I know that that's an ongoing case. I've mentioned that. I think they're probably not going to comment on an ongoing case matter at this time. We can perhaps do that. Moving along the agenda, that is our speakers that we had. The university has not raised their hand that they wish to opine any further, or the University System of Georgia. So with that, we have heard this. This is the bill with the changes I mentioned that the House has seen before. Given the recess situation and the time that we're moving forward, I'm going to ask if I'm sorry. Okay, I would. We have another joinee, another member join, Representative Scott Holcomb, if those that are keeping a list. So at this time, does this committee wish to take action on LC 490235S? Is there action? I have a motion and a second. Let me repeat that because Mr. Love points out I may have misspoke. SB 318, LC 490235S. You concur with your motion, Mr. Kelly? Mr. Reeves? I have a motion and a second. Is there discussion on the motion? Okay. No, I use it. Just to be clear, Mr. Love points out this is by committee substitute. I referenced the LC number, so that was my intent. It is by committee substitute with LC 490235S. Is there discussion on the motion? Discussion. Motion is do pass recommendation. No further discussion. Okay, we're going to have to do this with a roll call. So if you would, we've been practicing this on the floor all day. Yeah, we're going to have to go back and forth on Zoom, the folks that are on Zoom. Representative Kelly. Representative Reeves.
Aye.
Representative Bentley. No. Representative Bernal. Am I going too fast for you? Oh, no. No, I know you guys are. I was asking Mr. Love here.
Thank you.
Representative Clark. Representative Clark. No. Representative Dempsey. Aye. Representative Dickey. Aye. Representative Dubnik. All right, we're going to Representative Earhart on Zoom. Representative Earhart, you're on mute. Unmute your machine. We will come back to the Zoom folks. I told them I was going to give them every opportunity, and I'm going to do that. So we will come back to Representative Earhart on Zoom. Representative Gardner. No. Representative Holland. No. Representative Kausha. No. Representative Mathiak. Yeah. Representative Metz. No. Representative Park. No. We're back to, for those that are driving Zoom for us, Representative Perkle.
Yes.
Well done, Representative Perkle.
Thank you, sir. I love the math.
Representative Wiedauer. From Zoom, Representative Smyre. Representative Smyre. We will also come back to Representative Smyre. Representative Dreyer. Back to Zoom for those that are driving Zoom for us. Representative Knight.
Yes.
Again on Zoom, Representative Holcomb.
No.
Equally well done, Representatives Knight and Holcomb. Okay, we have, we're going to loop back. For the Zoom control room, Representative Earhart.
So all these issues right here that were provided.
If you can hear, give us a visual sign, and we're going to get Representative Earhart, give us a visual sign, and we're going to get Representative Gardner to look over this for us.
Just a moment.
Representative Earhart is recorded as an aye. Representative Gardner, you concur with that, right? You saw the, okay. Going back, Representative Smyre. Is Representative Smyre back on?
All right, so DCH.
Representative Smyre, I don't see him still on the line. Okay, let's call. All right, well, just an abundance of caution. I have for the bill, Kelly, Reeves, Dempsey, Dickey, Dubnik, Mathiak, Perkle, Wiedauer, Knight, Earhart. Against the bill, Bentley, Bernal, Clark, Gardner, Holland, Kausha, Metz, Park, Dreyer, Holcomb. Is there anyone that is, I'm sorry. Okay, is there anyone that has not been recorded? I'm getting there. We're just hang on. This is new to me. All right. Anyone that we have called upon that has not been recorded, not. If not, we're calling the roll. Representative Jaspers on Senate by substitute Senate Bill 318 LC 49023 35S. Is an aye. Does that conclude? We had her up there as a star for a moment, Representative Earhart. If you would total those. Yeah. Okay, and that foots with our. Okay, the motion passes 11-10. The bill moves forward with a due pass recommendation. That is the last item we have on the agenda this afternoon. Ladies and gentlemen, keep in mind of a meeting on Monday. Representative Metz has a study committee she would like us to look over. She talked about today, so keep in mind I will meet on Monday at the Representative Metz call if she wishes to hear that study committee. We're going to look for a meeting on Monday. With that, no further business for the committee will stand adjourned without objection. Thank you for everyone on Zoom. Thank you for the Zoom production crew. Without objection, we are adjourned.
All right, take
Hey,
care.
you too.
What happened?
What happened? Was that discussion only? Was that discussion only? We didn't vote, did we? Okay.